So thank you very much for having me as well. I'm very excited to be here and to be talking about such dynamic areas such as payment services in the area of crypto assets. So what I'm going to do is to talk about MiCA in the first place. So I have indeed, I would like, to talk about what MiCA is, why we needed MiCA in the first place, the taxonomy, so a little bit, the rationale for this new piece of EU financial markets legislation. And then after that, I will move to the, let's say, coordination between the existing European payment services legislation and the MiCA. So as I said, the first thing I want to tackle is why MiCA? So why we needed such a new piece of legislation? What is MiCA doing? What is the taxonomy? So the scope of application, which is very important, because it will help us understand how the MiCA, so this text, this legislative text is, talking to the payment service legislation. And, I think that it's pretty clear to everybody. Everybody knows that the market and market practices are much faster than the legislator. And this area, so the area of crypto asset tokens, is an area where this holds particularly true, and where the legislator really needed, to be in good shape as to chase, let's say, all the regulatory and supervisory challenges that have brought up by innovation. And in this respect, I mean, if you think about what a crypto asset is, and this is a legal presentation. So of course, I'm a law professor. I'm not going to the technicality and technical software perspective about crypto asset, but I would like, to as a lawyer, as a legal scholar, to just give you a very somehow, simplified, probably oversimplified representation of what we're talking about here. We are talking about a digital asset that is a digital representation of something. So if you think from a legal perspective what matters to us, I believe that it's, quite easy to understand that it's whatever it is inside this digital asset. So despite, the technology underlying this digital asset being particularly interesting, from a legal perspective, the digital asset per se is but a box or a container of rights, okay? So it is a means to perform something. And in this respect, what we are really interested about is the value or rights that are incorporated in this digital asset, in this digital box. And in this respect, so when we are concerned about the legal characterization of the digital asset, we have to focus on the nature of the rights or the nature of the value that is indeed incorporated in this box, in this digital box. Why am I stressing this out? Why am I, pointing this out? Because when crypto assets emerged and there was like an increasing interest in this new phenomenon, regulators started asking themselves, okay, but what do we have here? So what is the nature of these new products, these new means, these new digital representations of value? Are those things, are those digital assets to be considered as money, since we can use those things to make payment transactions? Are they financial instruments? And we had actually national competent authorities, so domestic, regulators, domestic financial supervisors that were also questioning whether domestic notions, as for example, the notion of financial product that is quite important in the Italian regulatory framework, whether, we could use such national domestic notions to capture what those new means, those new financial product could do. And I mean, let's say that at the very beginning, the national competent authorities in the European Union, but worldwide in general, I would say, developed a sort of functional approach, say, yeah, well, you know, what you have to look at is what you want to perform with these digital assets. So the function that is performed that somehow characterizes also the rights that are incorporated in this digital container. And you look, in fact, at intrinsic characteristics, and therefore the taxonomy and the potential application of a regulated regime, so a licensing regime, depends, in fact, on how you qualify these rights and consequently the tokens. Nonetheless, so despite, I mean, the questions being shared between the different national competent authority and between the different governments, we ended up in a situation of regulatory fragmentation, the regulatory differences, country-by-country approach, and therefore the risk of regulatory arbitrage, which, I mean, regulatory fragmentation, as you probably know, not only in crypto, in the crypto economy, but in general, is a big driver for the European Union to, you know, to step up and do something. So in light of the risk that at the end of the day, the end user, so the financial user, could suffer from this regulatory fragmentation and from the possibility of you know, regulatory arbitrage, European bodies, I'm using this general term, started, you know, raising some questions, started raising concern and doubt about the effectiveness of the existing regulatory framework to actually adequately, you know, react to these new challenges that the crypto assets are raising. And in this slide, you know, you see a lot of boxes and colors, and probably you can recognize some familiar names: European Banking Authority, ESMA, EIOPA. So here, I just collected some important documents, legislation level 3, issued by the ESAs, by the European Supervisory Authorities, between 2010 and 2019. You know, just showing, raising awareness about the risks that are associated with crypto assets. And you can see from the name of the document, warning on virtual currencies, warning on initial coin offerings, warning here, warning there. So of course, it's a document that wanted somehow to you know, tell potential financial users that it could be risky, you know, to invest, to hold. Invest probably is not necessarily the right word, but to buy, to purchase, to hold those kind of crypto assets. The interesting thing about all those documents is the legal basis underlying some of them, because if you look at the establishing regulation of the ESAs, you will see that there's an article that is Article 9 of all those free regulation establishing the EBA, ESMA, the EIOPA, that is, on the one hand, linked to financial innovation. So it's an article that is preoccupied, is concerned with what financial innovation can, you know, bring about. But even most important than that, most importantly, this article is saying that the European supervisory authorities can provide an advice to the legislative bodies. So somehow the fact that, you know, the European supervisory authority can you know, produce, can formalize the act, and can somehow, you know, knock the door of the European Commission, could be seen as the triggering event to the idea of proposing the digital finance package, where we also find the MiCA, the proposal of the MiCA regulation. So here I'm showing, you know, on the left side of this slide, the 3 ESAs is to represent the collection of all those warning documents that, in my opinion, but not only in my opinion, were somehow, you know, pushing or prompting the European, contributing, you know, to the action that the European Commission took in September 2020. We are the 25th of September 2020, and it's, I would say, a turning point in the history of financial markets legislation, because the European Commission, I mean, issues this, I mean, fascinating proposal about a market in crypto asset, very sophisticated, with a lot of, of course, references also to the MiFID. It's clear that it's a text that is somehow, drawing on the experience that the regulator gained over the years in financial markets legislation in general. But at the same time, it's also, a tailored ad hoc legislation. So very, very interesting, very fascinating. And what I found particularly fascinating about it, the first time I read it, I was very excited about it when I saw the text. And of course, every time I take I'm analyzing a new text, what I look at is the objective, because of course the goal that the text is pursuing is particularly important, and also to shed light on the specific revision. So I was, okay, what is the aim in the proposal? Huh? What is the aim of this regulation? And the proposal was somehow creating a sort of hierarchy, a pecking order of goals, even though of course they are on the same. Somehow it's, we can say that they're all, they have the equal standing. Yeah. But what I found very interesting is that when you think about financial markets legislation, and you also payment service legislation, usually the goal is to protect, amongst other things, is to, take adequate care of the user, the payment user, the financial user, the investor. So depending on the specific area of law, of financial law you're looking at, but it's the consumer, but probably it's better to say the user, that is at the epicenter, or at the same time financial stability, the soundness of the economic players, of the banks, or whatever kind of financial institution is involved in that specific market. Well, of course, those goals are mentioned as well, but the starting point of this regulation is we want to achieve legal certainty. We want to achieve harmonized markets. We want to achieve single rule book, and some sort of EU-wide legislation on crypto assets, avoiding what I showed you before. So avoiding regulatory fragmentation, different supervisory practices, different interpretations about what is what, and also, of course, in order to prevent moral hazard and regulatory arbitrage from coming about. Of course, I mean, the fact that the regulator wanted to achieve legal certainty doesn't mean that this regulation is covering the crypto asset ecosystem in its entirety. Why? Because actually the existing EU regulatory framework was capable of capturing some of the crypto asset. Because if you go back to what I said before in terms of what a crypto asset is, it's obvious that if you have a digital box that incorporates rights like those of a share or debt, this crypto asset would qualify as a financial instrument. And we do know that at the European Union level, we do have already a legislation that is taking adequate care of financial instruments, because financial instruments are the bricks, are the basis for the provision of investment services. And therefore, we have a regulated, we have a regime, we have a licensing regime, and we have everything. So crypto assets are just a means, as I said, a new technological, way to achieve certain results, to produce, to perform certain functions. And when those functions are already regulated, well, we use what we have. This is a principle I'm gonna tap on in a few seconds that is called technological neutrality. So you don't look at the technology underlying these means or the products. What you look at is the substance. So the very essence of the product, what it performs, the rights that are incorporated. And in this respect, given that crypto asset could be many things, and they could be, for example, financial instruments, we do already have the regulatory means to regulate them. So provided that the existing regulatory framework in the European Union was capable to some extent to cover crypto assets, what the MiCA is doing is integrating, is filling in the gaps that the existing regulatory frameworks had. So let's cover whatever is, not regulated. You understand, and in what I'm saying, of course, now I refer to MiFID and to the financial instrument. But what I said obviously covers also payment service legislation, because the payment service legislation, the PSD2, is a piece of legislation that we had already and that potentially could have been, applied to certain crypto assets. There was a little bit of debate, okay, but are crypto asset funds, because we know that the basis for a payment service for a payment transaction to exist is the transfer of funds. So the major question, the focal question was, okay, but when we transfer cryptos, are we transferring funds? Therefore, can we qualify this dynamic, this act as a payment transaction, and therefore, potentially a payment service that should be provided by a payment service provider? And yeah, that's the focal point. And we will see that in approaching this question and giving an answer, the MiCA most certainly helped in determining when a crypto asset could be seen, could be characterized as funds, and therefore, consistently come within the scope of payment service legislation. But so far, what I wanted, to stress is that the aim of the MiCA is to cover what is not already regulated, which is also bringing up quite a problem again, so quite an issue. That is the issue of coordination. That is the issue of the dialogue between the different pieces of EU financial markets legislation. Because if the MiCA is integrating what is not already, is regulating what is not already regulated, it means that we have to be very careful in avoiding overlaps. We have to be very careful in avoiding uncertainties about what type of regulatory framework could apply, right? Because actually that's also the very, goal, the starting point of the MiCA. We want to achieve legal certainty. And the fact of introducing a new regime, of course, is in the right direction, but at the same time could raise problems of, unclarity or doubts about the right regulatory framework that can be applied. And I will come back to that, because I believe, and many scholars, not only myself, but we believe that the coordination between the MiCA and the payment service legislation is critical, is delicate, is super important. So it's going to be one of the, definitely, one of the hot topics for policymakers, regulators, practitioners of the future. Today even, that we need to be monitoring closely. Not only because of the MiCA, but because the market is always dynamic and there are new things that are going on. Today, I'm going to talk mostly about asset reference tokens, e-money tokens. But for example, also the introduction of tokenized deposits, so a form of the deposit that is, indeed adopting the distributed ledger technology is raising question as to whether this is not funds, comes within the legislation of the PSD, or it is regulated in the CRD. I mean, there are many questions that are surrounding the area of crypto via the payment service legislation. A little bit further in these regulations, so I showed you the proposal, so to say, so the triggering documents, or the triggering the factors that were behind the adoption of the proposal by the European Commission. Also that all the legislative procedure was very interesting. I have to say, I was lucky enough to follow what happened behind the scene, and all the trialogue, the discussion between the Parliament, the Council, all the amendments. It was really interesting to see how difficult might be, to regulate a phenomenon like this. Well, the end result, if this regulation 2023-1114, which is in force, but it will be applied in different tranches, in different moments. So the first tranche will be applied in June, and regarding the first rules that are applicable will be those in relation to the issuance of crypto assets, and then a second tranche that will be applicable by the end of December 2024, with other rules, and in particular with the part of the rules concerning the provision of services. Yeah, in this respect, when you look at this comprehensive and quite big piece of legislation, one important, a general, structural aspect that you should take into consideration is that this legislation is divided basically in two sets of rules. A big set concerning the issuance, offering to the public, and admission to trading of crypto asset. And that's the part where we have Title 2, 3, and 4 of the MiCA, that is dealing with such part. And the second set of rules that is dedicated, that is concerned with the provision of services. Okay, so issuance, provision to the public of crypto asset on the one hand, and provision of services on the other hand. Of course, I mean, the regulation is covering other things. It's covering market abuse. I mean, it's really a comprehensive text, but one important element, or in terms of structure of the text, is this important distinction about the issuance and provision of services that we have to keep in mind. Quite rapidly on important definitions that we need to have in mind, to keep in mind, in order also to address the relationship between the MiCA and the PSD2. The MiCA provides a definition of crypto asset that is quite very broad, particularly elastic. That is the following. So crypto asset means a digital representation of a value or a right which may be transferred and stored electronically using distributed ledger technology or similar technology. It's a definition that is totally different from the other definition that we had in Europe. You probably know that the first EU definition about crypto asset is the definition of virtual currency that was actually provided by the 5th Anti-Money Laundering Directive, which is also quite a fascinating definition, because it's a definition that shows how difficult it was in 2018 to start, taking a picture of the phenomenon. It's a definition only in the negative, like it's a digital representation of a value that is not necessarily issued by a central bank, blah, 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 blah. But it is used as a means to make transaction. Well, now we have a totally different definition from the one that is, the style of the definition is completely different from that in the anti-money laundering regulation. It's much more straightforward. And you know, the fact that is so high profile a definition is justified by the fact that we want to have a category that is capable, a definition, a notion that is capable of being future proof. This is a definition that wants to be capturing, wants to be intercepting all the new products that the market can invent somehow. Look also at the fact that the definition is referring to distributed ledger technology or similar technology. Imagine that tomorrow we do have a new technology that is not called DLT anymore, but it has, you know, features that are very similar. Well, this notion, this definition will be capable of capturing also this new type of crypto asset based on a new technology, but still similar to the one in place. I think also in relation to this topic, more general topic of coordination between different regulatory framework, that is noteworthy the fact that this definition of crypto asset will be used also by the anti-money laundering legislation. So the legislation that is projected at preventing money laundering, so obviously a well-specific goal, totally different from the goal that is pursued by the MiCA, nonetheless will talk the same language. We will have, you know, perfect coordination between the bricks, as I said. So the basic concept that we need in order to create and build up the specific regulatory framework. Same language, same concept. And this also means less room for regulatory arbitrage, moral hazard, and circumvention of the legislation. Now, if you're following my argument, and we just said that the MiCA is covering what is not already regulated, right? So if we have a crypto asset that has the rights of a financial instrument, we call this crypto asset security. We call this crypto asset financial instrument, and therefore we come within the scope of the MiFID legislation, right? If we are okay with that, so if we understand this specific perspective of the MiCA, filling the gaps that the existing regulations, EU frameworks have, we also understand the taxonomy that we have in the MiCA. The MiCA, besides providing a general definition of crypto asset, this one that is applicable in general, then it provides three types of tokens, three types of crypto assets that are covered, that are regulated in the MiCA, because they don't find in another EU piece of legislation the basis to be regulated. And what are those crypto assets? E-money tokens, asset reference tokens, and a residual category that is called other tokens. So everything that is not captured, that is not intercepted by the first two categories, is in this last box, in this last category. So let's briefly on the three categories. The e-money tokens are a type of crypto asset that are pegged to the value of one official currency. So they purpose to maintain a stable value by basing themselves, by referencing to the value of one official currency, the US dollar, the EU, the euro, and so on and so forth. The asset reference tokens are a type of tokens that are, you know, pursuing the same goal, but in a different way, and the name pretty much tells you. So the asset reference token is a token that is not an electronic money token, but that purports to maintain a stable value by referencing to any other value or rights, or a combination of them, including one or more official currencies. So see how also the legislator, you know, is proceeding, is saying, okay, e-money token is this thing. There's this relationship, this, you know, stability that is based on the reference to a specific, to an official currency. Then if you're not an e-money token, then you might be an asset reference token insofar your stability derives from blah, 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 blah. And then other tokens, actually, I didn't copy pasted the exact words because I think there's a part in the MiCA that says, if you're not an e-money tokens or an asset reference tokens, then you come within this category of other tokens. So everything that is left, in this broad category, we also find the utility token. So a type of crypto, the utility token is a type of crypto asset which is only intended to provide access to a good or a service supplied by the issuer of that token. The first two categories are also known as stablecoins, exactly for the reasons I explained before, because there's this feature that ensures the stability of the value. So the characteristic is that this token wants to maintain a stable value by referencing either to just one currency or to a basket of other assets. So the two categories of e-money tokens and asset tokens are a type of stable coins. So they are stable coins. If we do have a token that is not a stable coin, could be it comes within the other category, because yeah, this last category, this residual category, is supposed in fact to cover what is not covered by the first two. Yeah, so as I said, the looking at the coming to the first part of this text, just to give you some you know pointers, because it's really a big text, and our you know the focus of this presentation is the relationship between the MiCA and the PSD, or the payment service legislation. Yeah, what is the scope of application? As I said, this regulation applies to the issuers, authors, and crypto asset service provider, and their regulation is setting out requirements concerning transparency and disclosure in relation to the issuance, offering to the public, the licensing, you know, procedure, so authorization and supervision of crypto asset service providers, issuers of asset reference tokens, and issuers of electronic money tokens, operation, organization, and governance of the issuers, protection of financial users, and measures to prevent market abuse. The scope of this regulation is limited to crypto assets that do not qualify as financial instrument, deposit or structured deposit, funds as defined in the PSD2, or insurance or pension products, for the reasons I told you before, because this regulation is interested in covering only what is left from what is not regulated elsewhere. Even though I think it's later, we will see that when it comes to funds, there's an exemption, because obviously, I mean, it makes sense to say this legislation, the MiCA, is not interested in funds. Why? Because, you know, we do have already a legislation. When we are touching funds, mostly it's because we are concerned with a payment. So when we are transferring, you know, withdrawing funds, it's a payment matter. However, we will see that there's an exemption, because this regulation does not apply to funds unless we talk about e-money tokens. I'm already anticipating something, that is, we will see it's quite a crucial topic. And this something that I'm anticipating is that e-money tokens, so the first type of crypto asset that we mentioned before, e-money tokens are funds. Actually, they are e-money, so they are considered to be e-money in light of the definition that we have in the e-money directive, and consequently, being e-money, we know that they also, qualify as funds. So you already somehow you can perceive, you can feel the this, how delicate could be this relationship between the PSD and the notion of funds on the one hand and the scope of application of the MiCA. Yeah, I think we can actually skip this part on the there are some references that you could use for yourself, like some reference to, for example, decentralized finance, whether or not decentralized finance is covered. But I would like just to, spend 1 minute on this principle, because it's an important principle that informs, in general, financial markets legislation. And the principle is the one that we apply the technology neutrality. That means same activity, same risk, and same rules. Therefore, every time we have a crypto asset fall under existing EU financial market legislation, it should remain regulated over there, okay? And why am I, sorry, I'm speeding up because I see that the time is going very fast. Keep this principle in mind, because it is, I would say, I want to question, I want to discuss with you whether or not this principle holds, whether or not this principle is complied with when we talk about e-money tokens. So that type of token that purports to maintain a stable value by referencing to a single currency. So here I'm again mentioning this principle, this recital, because it's quite important. Why? Because I told you that the scope of application of the MiCA is peculiar when it comes to the funds, because it's the only item in the list where the regulator says, yes, funds are excluded, but not in the case they qualify as e-money tokens. Because in this way, this was the only way, this exemption is the only way to make sure that e-money tokens come within the scope of the MiCA. There's some reason why we want e-money tokens to be regulated. And why is that? Because e-money tokens should be deemed to be electronic money. I told you before that the same MiCA, Article 48, paragraph 2, is telling us that e-money tokens are e-money, which, of course, brings us to what electronic money is, a definition that we find in the e-money directive. I think you mentioned this definition many times, is during this course, electronically including monetarily stored monetary value is represented by claim on the issuer, which is issued on receipt of funds for the purpose of making payment transaction as defined in the PSD1, but okay, the reference is in the payment service legislation. And of course, the fact, I repeat something I said, but it's very important, saying that e-money tokens are e-money entails that e-money tokens are funds for the purposes of the application of the payment service legislation. In fact, if you look at the definition of funds that we have in the PSD2, we see that funds are banknotes, coins, scriptural money, or electronic money as defined in point 2, which means banknotes, coins, scriptural money, or electronic money also in tokenized form. Electronic money as we used to know it, and electronic money in the form of electronic money tokens. this was, the fact that certain crypto assets could qualify as e-money tokens and consequently could also come within the scope of the PSD2. This perspective, this view, was a stance that was taken by the European Banking Authority and the European Central Bank well before the introduction of the MiCA, so well before a text, a regulation telling us that e-money tokens are e-money token, are e-money and therefore funds. Because the European Institute, the European Central Bank, this institution and the agency told us, look, insofar you do have the rights, you do have the features, the characteristics of e-money, so they represent a claim on the issuer, those crypto assets are e-money. So it's a view that was expressed even well before the introduction of the MiCA. However, and now I want, to somehow ignite the discussion or just think together with you whether, in light of what I said, so in light of the fact that e-money tokens are e-money, I want to reflect on the correct application of the technology neutrality principle. Because honestly, if the technology neutrality principle says you look at the substance of things, and if something is called in a certain way, it qualifies in a certain way, you regulate it in the, in the specific regulatory framework that is relevant, irrespective of the technology. Therefore, if we stick to this principle, I would say that e-money tokens should be regulated in the e-money directive, right? If the same MiCA is telling us e-money tokens are e-money, I would say, well, then we regulate them in the e-money directive. We might regulate them in the PSD2. Why are we regulating them also in the MiCA, right? I don't know if I'm explaining myself, but there seems to be, a contradiction, a fraction, a sort of a tension, or not a paradox, but, some doubts about the proper application of this. And, somehow we find the justification for what I'm saying, and also confirmation that probably here the principle is not, precisely accurately applied in recital 19. Because in this recital, the regulation, the legislator says, because e-money tokens are crypto assets, which I read like they are based on a specific technology and can raise new challenges in terms of protection of retail holders and market integrity, that are specific to crypto assets, they should also be subject to the rules laid down in this regulation to address those challenges. And this also that I have highlighted obviously refers to the fact they are already regulated somewhere else, that is, in fact, the EMD2. So what I believe, or that's my opinion, of course, but I think that the wording is pretty much, confirming what I'm saying, is that, e-money tokens should be regulated by the EMD2, obviously, because they are e-money. But at the same time, given that they're based on a specific technology, and therefore we might have additional, specific, more than additional, we might have specific risks that are stemming from the fact that they are crypto assets, so they use a specific technology, we also have to apply the MiCA. And in fact, if what I'm saying is also, of course, not only in the recital, but also in a real, in actual provision, Article 48(3), Title 2 and 3 of the EMD2 shall apply with respect to e-money tokens unless otherwise stated in this title. You apply the EMD2 unless the MiCA is derogating the application of it. Example of derogation, Article 49, Paragraph 1, by way of derogation of Article 11 of the EMD2 in respect of the issue and the redeemability of e-money tokens, only the requirements set out in this article shall apply to the issuers of e-money tokens. Now the time is going very fast, so I can't really, but going to the why we have this derogation, but we have an example in this Article 49 of, a situation where the EMD2 is not applicable due to the dynamics and technology of the e-money tokens, and therefore we have to disapply, we have to, derogate to the application of the EMD2 and rather apply the MiCA. Now, we qualified the token. What happens when we perform an activity based on this token? In particular, what happens when we have a service based associated with this? Why is this important? Because it might trigger the application of the PSD2. At the same time, however, also, as I told you from the beginning, the MiCA is covering the provision of services on crypto assets. Therefore, in theory, the MiCA is covering the provision of services associated with e-money tokens. Now, look at the types of services and activities that are listed in the MiCA. Those are the services that could be provided according to the MiCA. That obviously trigger a specific licensing regime. You need to be a regulated entity already. You need, otherwise you need to get an ad hoc license. But in any case, what matters is it's a type of activity / service that comes within the scope of the MiCA. Providing custody and administration of crypto assets, operational trading platform, exchange, crypto via funds, exchange, and then placing of crypto assets. And I'm just focusing on those highlighted, providing transfer services for crypto assets on behalf of client. As I said, the provision of this service requires for the entity to be authorized, either as an already regulated entity or following the licensing procedure that is provided for enshrined in the Title V of the MiCA. Why did I highlight those activities in the list? Custody and administration, placing of crypto asset, transfer services for crypto asset on behalf. Because if we assume that this business, this activity refers to an e-money token, it means that we might be placing a crypto asset that qualifies as e-money and therefore funds. Placing of funds or transfer services of funds on behalf of a client, in my world, is called payment service. So in other words, what I'm saying is that some of the services that are listed in the MiCA recall the payment services. And in fact, this is acknowledged by the same MiCA. The same MiCA, in a couple of recitals, says some crypto assets, in particular providing custody and administration on behalf of client, the placing of crypto asset transfer services for crypto assets on behalf of client, might overlap with payment services as defined in the PSD2. Depending on the precise feature of the service associated with the transfer of e-money tokens, such service could fall under the definition of Payment Service Directive. I look at the difference between recital 19 and recital 93. The first recital is referring to crypto asset in general. The recital 93 is specifically, and that's important, talking about e-money tokens. But at the same time is also saying, when you touch e-money tokens, it could, not it shall, not it must, it could come within the scope of the PSD2, depending on the precise feature of the services associated. This recital, I think, is really, really interesting because, of course, it is bringing up the problem of coordination. It is saying that when we are talking about e-money tokens, there's this, possibility for an overlap. It is not clear, but it's also saying that it's not always the case that the service transferring e-money tokens is a payment service. It depends on the precise feature of the activities of the service. Okay.
And Andrea, this is a really critical issue, and I just want to give participants actually an opportunity to ask a couple of questions on what you've covered and also the previous points. And I'm conscious of the time actually as well. We're quite close to the break now. Can we wrap up and turn to a couple of Q&A from the audience, because I'm convinced I certainly have a question on this, but I'm convinced that we might have some questions on this. Sorry to cut you off there mid your services. So yeah, with the EMT slide, you've really done a fantastic job in explaining the interaction between MiCA, PSD for EMTs, and also of course the payment package. Just to ask you the direct question, what is the fix for this? I'm assuming it's the Commission clarifying the application, but like how do you think they should actually do that?
That's yeah, no, thanks for yeah, it's very critical, and so I think and it's linking, the answer to this question is somehow linking to the upcoming part of my presentation. We should also, on the one hand, I believe that we should emphasize what the characteristics of a payment services of a payment service are, like, okay, but what is a payment service? And if you look at the payment service legislation, what you see is that, it's all based on the idea of an intermediary that is executing a payment order that comes from a payment user. So the payment transaction, this link between payment transaction, payment order, and execution of the payment order done by the intermediary is, producing, it is at the end of the day, making the payment service. And now what I'm questioning, or what a potential answer is, okay, but can the technology, envisage a different dynamic where, for example, it is the person, the financial user, that is autonomously on a peer-to-peer basis transferring funds without the execution on behalf of the intermediary. And therefore the intermediary, which is still there somehow, but is playing a different role, for example, enabling the client, the individual to perform this transaction. So I frankly believe that what we need is the clarification of what a payment transaction is, especially in this very moment that we have the package. I mean, there's, again, the financial legislation is really, really fluid in this moment. We have a lot of updates, changes, and developments, and we have now the proposal for the PSR and PSD3. And I think that's the right moment also, to account for the technology advancement and the fact that probably if we want, to give separate scopes, or, to provide an area for the services in the MiCA and an area for the PSD, there might be a space, in fact, where it's the financial user that is, executing somehow the payment transaction without the intermediary doing that.